So good morning and welcome to today's class on the Kentucky Statutory and Administrative Regulation changes for 2019 and 2020. We've got a lot of material to cover, and people generally have enjoyed getting this information. It's very important to get. If your first Zoom meeting, it's very similar and as close to identical as we could make it to a live meeting or a live seminar. Let me tell you that I'm an attorney. I'm licensed in Kentucky and in Indiana, and I have been for 35 years, 36 years. The vast majority of my practice has been everything that goes wrong with real estate. And hopefully that experience is good for you. In 36 years, I've probably done 36 closings. I've probably done 36 hundreds or thousands of lawsuits, and including representing you in front of the Kentucky Real Estate Commission on rare occasions when you get sued. I'm one of several lawyers. Jenny Lawson is on the call, as a lawyer many of you are familiar with, has done a lot of E&O representation. I've done some. And I put this seminar together shortly during the course of the KREC amending their regulations and after their statutes were amended. Because I knew there were substantial changes going on and that they were going to be very important and that we needed to be aware of them. The statutes got changed last year and were effective last year. The regulation change was a process that took many months and had many discussions. I attended as many of those KREC meetings as I possibly could. I certainly did not get to all of them. No one could. But I got to about half of them. I think I have some insights on the regulation changes from that process. Most of these regulation changes are actually already effective and were effective as of December 19th of last year. There's a delayed effective date on a couple of these, and the most important delayed effective date has to do with the advertising regulations that we'll talk about, and those are effective June 1st, which is not very many days from now at this point. So your timing is good to be on this call. Some forms have been given an extended delay date. They were originally given a 6-month extension date, but the KREC on some of the agency forms has extended that again to an indefinite period of time because of some problems with the forms and getting news out about them as well, but mostly some problems with the agency forms. Jenny Lawson, I, and some KREC folks and general counsel are on a task force. We've been pleased to work with them, and they've been receptive to our recommendations about the changes to get those agency forms straightened up. And that has to go also through an administrative process, however. And once it does, then we'll be able to, and they've approved whatever they wanted to do, then we'll have hopefully a new regulation that everybody will be authorized to use. And at long last, I apologize for this, I've got my PowerPoint straightened up, and there we go. Everybody give me a round of applause. You didn't even, did you sense the panic on my end or what? All right. There we go. All right, now we've got it going. We got that, we did that. I know who you are thanks to that poll. So we're going to talk about these new statutory and regulatory changes. And we're first going to talk about the statutory changes. There are actually very few of those. The regulatory changes are much more voluminous, and they are now broken down into seven regulations. So one of the one of the clerical changes that's made to the regulations is there used to be, I'll say 40 of them, there's now 7. It does not mean that there's 1/10 as many regulations. In fact, there's more, they're just divided up differently. So, and that frankly, they're divided up in a better way now. This was the first time in my lifetime of practice that the KREC did a thorough regulatory review and went through every word, every comma, and decided what they needed to say, what they wanted to say. So they did a very thorough job. And the only way I knew to and then, I'm sorry, I'm backing up here a second. We're also then going to talk about the forms because those went through some changes as well. All right, the only way I knew to present this material was to show some things that were removed, because sometimes you can't tell what's important unless you see what went away. And so I did this through a color coding system, and anything that's light blue means it's gone. Red means it's new and important. You'll see that I thought everything was important that was new, just about. Every now and then I put some notes in here that just, they're my narrative, my commentary. So those are in green. And this little purpley splat mark I put on the slides that are really important, because although they're all important, some things of course are more important than others. You'll notice that splat marks are on almost everything, because even though I tried to be discriminatory or to make some choices, it seemed like everything looked important the more I looked at it, or almost everything did. So these statutory changes, again, they went into effect June 26th of last year. So these statutory changes, there's only a handful of them, but those went into effect last year. Some of these are things that you as licensees probably will never even realize. They're important legally, but they probably don't affect your day-to-day life, beginning with how many members are there on the Kentucky Real Estate Commission. And the answer is now 7, or I should have said Kentucky Real Estate Authority, 7. Used to be 5. You would never know the difference about that. A terminology change, which cleaned up some inaccurate terminology. As you know, you've heard people for decades say that they were going to put their license in escrow. I'm using air quotes here. That's what we always said, and that is what, in fact, the regulations used to say, that you're putting your license in escrow. Well, that's always been a misnomer. You don't put licenses in escrow, you put money in escrow. And so they've corrected that, and in the statute and regs, and now everywhere you used to talk about being an escrow, you're now going to say inactive status. Terminology change, but an important one. Substantively, what about going in and out of escrow is being tightened up. The KREC did not like the fact that, in their view, some licensees were gaming the system, and this makes my head hurt to even explain it, but I guess those that were allergic to taking continuing education would roll up into late December. They would not take their continuing education, and they would throw their license in escrow. Then they would bring it back out later in the spring. They would still not take continuing education, and they'd roll into December of the following year and do it again. And it makes my head hurt to even think about how you do all that, but I guess you could play that game quite a bit, and the KREC obviously doesn't like that. So they've made that harder to do. Also, the KREC was rightly concerned that just because you were in escrow or in inactive status didn't mean a claim couldn't come up about you, since the claim could have been incurred when you were active. And so the statute got changed at the request of the KREC to require, as part of going into inactive status, you must provide this extended reporting period coverage. We shorthand that as ERP, extended reporting period. Some people call that a tail policy. So it's a policy that covers you after you're no longer practicing. So you will, in order to go into inactive status as of June of last year, You could not just file a form and be done with it. You now have to prove this extended reporting period coverage is in place. To come out of inactive status has been made more difficult both by the statute and as well see by the regulation. First of all, to come out by statute, you're going to have to go through a criminal background check. So almost half of you said you were brokers, so you might just let your agents know, just all of this, but this in particular is that if they do roll into inactive status to come back out, you're going to have to go through that criminal background process. Also, you're going to have to pay the fees, fill out the forms, and starting January 1 of 2021, you're going to have to make up, with some limits, you're going to have to make up the continuing education you missed. So it will no longer be a ploy to avoid continuing ed. We'll talk more about the limits on that when we get late this afternoon, when we get to the point about talking about continuing education requirements. One of the changes, and probably one of them you noticed, I'm sure you've noticed already, is that when you renewed your license back in March, you renewed a 2-year license, not a 1-year license, which is what you've done through your whole career, but now you've renewed it for a 2-year period. I'm sure you also noticed that you didn't save any money by that. You had to pay twice as much, but you'll pay it half as often. So there's no monetary effect on you, but there's an administrative work reduction both for you and for the KREC, because then you all only have to do this every other year now. In tandem with that, your continuing education requirements changed. And I will tell you, before I even start this, I'll tell you if you ignored this happen, you'll be just fine. But what this new this statute does is it lets you front load your education during a 2-year window. So you can take more education in year 1 of the 2-year license cycle. So for instance, this year, you can take more than 6 hours of CE. And if you do, you can bank it and let it roll into next year. You cannot backload your CE. You cannot refuse to take anything this year and then try to take it all next year. That won't work. It has to be at least 6 hours in year 1. It's just that you could take as much as 12 hours in year 1 and roll it forward. The other thing about the rolling forward of the banking you need to understand is that you cannot roll from one 2-year period into the next 2-year period. So it's only within a 2-year period. So if you ignored that, you'll be just fine, because you'd go ahead and take 6 hours every year, 3 hours of it being law, you would be just fine. But you can front load it if you want. All right, that's the statutory changes. The regulation changes, again, most of those went into effect December of 2019, except there are a couple of them that got some delayed effectiveness. Now, the thing I want to say about these regulation changes before we get into them is that a 5-member body is responsible for these changes. You can imagine getting 5 people to agree on anything. In the middle of that, some of the 5 came and went. I think during the time that these regulation changes were being made, you can imagine in any business, if you were going to change all your rules, you'd probably want to run them by your lawyer, wouldn't you? Right? Well, during this time, they had 4 different lawyers. So, you know, I'm not denigrating the work. I'm not denigrating the people by any means, because they work really hard. But sometimes things probably didn't go as smoothly as you would have wanted them to, or they would have wanted them to. The other thing is after that process, so the KREC spends all that time, and they come up with what they think is a fine-looking thoroughbred. They got a nice-looking horse. Then they send it to the legislature. You know those people, right? And so now you've got this other body that gets a hold of it, and in goes a horse, out comes a camel. So everything that's in here that you like or don't like isn't necessarily the fault of the KREC. Some of it gets credited or blamed on the legislature because they made some tweakings. And sometimes when they tweak things, they don't really have a full appreciation for all the consequences of that. So that's just my defense of the regulations. Regardless of what we think about them, this is the law, and we're going to all have to follow it and deal with it. The most glaring camel issues, again, the task force is trying to deal with on those forms. Believe it or not, this 6-hour class is a quick review. Can you believe that? 6 hours is quick. And I only pulled what I thought were the more important changes, but I certainly don't want to discourage you from getting out and looking at all of them. So here's the link. If you want to look at the entire regulations from beginning to end, all 7 of them, 29 pages or whatever it is, there's the link to do that. So you've got that, and I certainly encourage you to take a look at those. And even after today, anytime that something comes up, you probably want to do that. Look things up as opposed to just pulling them up on this slideshow, because obviously I did some cutting and didn't necessarily include every word everywhere. All right. One of the first things that happens when you're going to totally rewrite a license law is you've got to repeal all the old stuff. And I didn't include in here those are called repealers. I did not include every repealer in here, but I did want to point out a couple of things that got repealed and are just flat gone. And I don't know how important these are in your practice, probably not a lot, but the regulation that related to promoting out-of-state property, it's gone. It went away and it never came back. So if you were doing out-of-state property promotion, the KREC, what I heard them say is, it's out of state, we don't have jurisdiction over it. The other thing that's gone is timeshares. A lot of the timeshare regulations went away, and registration of those. There are some other regulations that deal with timeshares in some context, but anything the KREC did is gone. Another thing that's totally gone is the unlicensed personal assistant regulations. And I'm going to ask for a show of physical hands. Now that I told you how to do it electronically, this time I want you to do it with a real live hand. Show me by hands how many of you had an unlicensed personal assistant. It's not usually very many, but it's a couple of people. And so just so you know, you can still have an unlicensed personal assistant. It's just all those regulations that were contained in 11-440 that told you all the do's and don'ts about those people and what you had to do to supervise them and train those people. That's gone. My review would say that they can still do the same things that they did before. It's just now there's not a specific regulation defining that box of activity. Okay. So also they repealed our internet advertising reg, and you'll see that we do have internet advertising regulations, but they're a little different than they used to be. The first regulation, new regulation, is they put in one place, thank goodness, all the definitions that relate to your regulations. They're all in one place for definitions. And just to give you a feel for this, this particular section of the code used to have 5 definitions. Now it has 47. That's how dramatic the changes were. Now, in all fairness, I will say they didn't really add 42 new definitions. They probably added 20, but the other 22 or so were just scattered all over your regulation book. You know how hard it was to find things. Well, they've put them all in one spot. All right, the first purple splat I put on here is about the definition of what is advertising. And I'm going to give you a sneak preview and tell you that what is advertising, things that are advertising are going to be subject to some new rules about how big the broker's name has to be in comparison to how big the agent's name is. So if something is advertising, it's going to be subject to that limitation. So they tell us that advertising means what you would think it is, making known a specific, two kinds of advertising exist as I see it. Making known a specific property for sale. Whoops, I'm trying to get my counting fingers in the screen. There we go. A property for sale or lease, or your services. So advertising a property or your services counts as advertising. Now, there's some things that do not count as advertising, even though they would be an ad for property or for your services. Something that is not an advertising is a private communication between you and your client or a prospective client. So what's a private communication? Well, you run into me in the grocery store and you say, hey, Dennis, you've been talking to me about fourplexes forever. I happen to have one listed right now. Well, that was a private communication. You were just talking to me. Or you send me an email that says the same thing. That was a one-on-one communication that does not count as advertising and therefore is not subject to these limiting regulations. Also, what is not advertising is a directional or pointer sign that is solely to provide directions to a listed property. And here's the catch: includes no identifying licensee or brokerage information. So you've got to think about whether your directional and pointer signs are advertising or are not. Just because they're advertising is not the end of the world. It just means you're going to then have to look at them. So again, give me I'm going to see if I can do something. I want to put this in gallery mode so I can see more of you. There we go. I got more faces here in front of me. Not all of you. Hi there, got you back. Let me see a show of hands. We'll do physical hands this time since it's simpler. How many of you have directional or pointer? Everybody's hand should be up, right? You've got something that's open house this way or come this way, whatever. Okay, put those down. How many of those directional or pointer signs have identifying information to identify you or your firm? I'm thinking most of them, but so you got to think about it. So it's okay if they do or they don't. You're just going to have to think about what that means as we come forward. All right, I'm going to scrunch down my pictures. There we go. So, whoop, sorry, I got to back up to go forward. All right. So just remember, pointer signs might be considered advertising and they might not. It depends on whether they have that identifying information. Some of these definitions, like this one, I think, tells us a sales associate or broker who's affiliated with a principal broker. I don't think that that was terribly new, but I still wanted to include them. For the first time, we actually have a regulatory definition of what agency is. We've all thought this is what it meant all along, but for the first time, we actually have a regulation that says so. I do want to point out that the regulation includes this relationship that can be created, and they explicitly included by oral or written agreement. And so that will have ramifications. Now, usually, especially if you're representing a seller, you're doing this by a written agreement, like a listing. But it's clear that you can create an agency agreement verbally, and you usually probably do that with buyers, don't you? I mean, most buyers, in my experience, aren't signed buyer broker agreements, and yet you're their agent. You've created that relationship orally. An agency consent agreement is one of these new forms, and this is one of the forms that has some logistical problems to it, but barring that, it is a form that's prescribed by the commission, and they tell us it establishes the agency relationship in writing. You'll see it, and you'll see what the problems are. They tell us what a branch office is. You see the black, that was always there. The red is the new words. I just thought this was important because throughout these regulations, you're going to see that the KREC has made you brokers much more accountable. And they've gone to some trouble to say so. And they've made it very clear that they can enter and inspect your documents. This regulation, like many others, codifies what has always been their practice, but now they've made it explicit that they have the right to inspect records. Business relationship, of course, is one of those things that you're going to end up disclosing on an agency consent agreement, and it tells us what that is. Owning an ice cream store together, owning real estate together, any prior representation of that person, all of those things count as business relationships. Very little change in this definition other than they did add lease. So if you've represented somebody before in a lease relationship, I know we had almost a third of you said you were property managers, so you've got a lot of leasing relationships going on. The regulations used to say throughout, used to talk about your relationship to a party, and now that's taken out, and instead it's referred to as a client, and you'll see why. So the client is the person that you represent. And you've either entered a written agreement with that person, or for whom you complete an offer or to purchase or lease, or by oral agreement, you perform acts of real estate brokerage. So I think that's what you always thought it was, but again, they're just making that explicit. And the client, they tell us, is the person or persons authorized to sell or lease the subject property, or entity or entities. So you've got, you know, LLCs, corporations, all kinds of different entities that you might be dealing with. One interesting change that the KREC made in their definitions, interesting to me anyway, is what is a commercial transaction? And you all know that what's commercial is going to be significant because it's going to affect when you have agency disclosure requirements, right? And that's still true. To me, it was just very interesting that in the definition of commercial transaction, they took out the exemption for agriculture. So that means a property that is purely agricultural is commercial. Now I know that you're sitting here in Jefferson County and you're probably not selling a lot of farmland in Jefferson County. But I will say that it's interesting to me that in a state that is heavily agricultural, that they would treat agricultural transactions as commercial. Maybe they're figuring that the single family residents sitting on the farm would take care of that problem in the case of some folks. But my parents were dairy farmers, and although my grandparents were certainly hardworking, and I would say they were intelligent people, neither one of them finished high school. And it seems a little funny to me that you would have them excluded from agency disclosure and would have considered that transaction commercial. Just seemed odd to me, but so I just thought it was noteworthy. They gave us a definition of condominium. And of course, as you know, there's going to be a condominium disclosure requirement, or there has been since January of 2011. So for the first time, they actually came up with a definition of condominium. I won't sit here and read it to you. I will tell you, just, I did a lot of condominium and HOA work back when I was actively practicing. Had anybody bothered to ask me, I wouldn't have come up with this definition, because to me, a condominium is something that's developed under a master deed, end of story. All of this other doesn't mean a lot. If it's developed under a master deed, then it's a condominium pursuant to KRS 381. So that's the real definition that's going to matter for condominium disclosure requirements. Now, something that is certainly significant is, we talk a lot about your duty of confidentiality, and we've talked about, well, what is it that is confidential? And it means what it always meant. They went to the trouble to amend this to tell us that that includes things that are sent verbally or in writing, but they added something. So it means what it always meant. You see most of this is in black. The thing they added is anything else that's designated in writing as confidential by the client or prospective client. The thing I would like, if you've got this, we sent this to you on a 3 to a page notes, notes handout. If you bothered to print that, I apologize. I know it was still, when I printed it, I still had 136 pages, and that was 3 to a page. So I apologize for that. It's a monster. But if you're taking notes, what this means is that even something that has no business relevance whatsoever, doesn't have anything to do with their marketing plan, their motivation to buy or sell, but your client just wants to keep it private, then you need to keep it private. I had a friend tell me that they were buying a house, and part of the reason they were buying a house was because they were pregnant. Had nothing to do really with their financial means or anything else, but they didn't want it all over town that they were pregnant. Don't know why, doesn't matter why, it's their business. That's the kind of thing they wanted to keep private. That's the kind of thing you'd have to keep private if your client tells you so. Now, the regulation literally says if they tell you so in writing. Frankly, I'd say even if they tell you so verbally, then you should keep it private. Throughout the regulations, we're going to see what your duties are to various people, including consumers. The consumer is in effect the person that you do not represent. If you represent them, they become a client. The regulations tried to get more consistent in our wording and try to use the term contract deposit everywhere. If you remember, the old regulations sometimes use the word earnest money, sometimes they called it good faith money, sometimes they called it the contract deposit. So they tried to clean that all up and call it a contract deposit and be very specific about that. And an interesting change is in the definition of delivery. Now, delivery always meant mail, hand, fax, email, and it used to say messenger, and I bet none of you ever bothered to send anything by messenger, probably. They took messenger out, and instead they put in other legal means. And my note is, I wonder if what they were trying to anticipate is some of you are so tech savvy that you don't even email documents to people. You share them through some kind of document sharing system like Google Docs, or I use Dropbox as the example because that's the one I use. And certainly that is delivery, I think, and they've taken cognizance of that, as that is another way of delivering a document, is you don't even deliver the document, not even by email. You just make it available through some kind of file sharing arrangement, right? How many of you do that, by the way? Let me open my gallery back up and let me see hands on file sharing. Yeah, see, it's like, oh, close to 40% of you probably. And so that is clearly allowed. I don't know that anybody ever got in trouble for it before, but it was at least questionable before whether that counted as delivery or not in the past. All right. It is not the top of an hour, but they tell me the coffee drinkers among you are already getting nervous and wondering when that break is going to come. Well, the answer is now. We're going to take a 10-minute break. And remember, about a minute before the break's over, I'll make some kind of annoying sound. I'll see you back in 10.
Hey, Dennis, is it any way possible you can put slide number 34 back up for a second?
Whoop, I'm sorry. I'm sorry. Say that again.
I was wondering if you could put slide number 34 up for just a second.
Sure, absolutely. There you go. So the part of that that's always been there, whoop. I'm sorry. There we go. Most of that's already been there all along. Confidential information is information that would materially compromise the negotiating position of a party. What they added was the part in red, which really didn't change what was confidential. And I'm going to flip down to 36. The part that then's totally new is anything else that the client would designate. But I'll go back and leave it on 34 for you. Is that what you needed? Whoop.
Yep, got it. Thank you.
Oh, okay, sure. Absolutely. We're on both.
Stepped away for a second, then everybody's gone.
That's the AE's nightmare. Is wait a minute. I had a room full. Where did they go? I've got this. I can't. Thank you. I do. It is me.
But I did notice on it. See where it says add title.
You know what's weird? They don't show. Right. But they don't show when we play it. It's the weirdest thing.
So you need to make this present. You need to pull it up as a presentation and click through it that way instead of this. Because this is your edit view. No, your edit view.
Oh, you're on the.
I can see. I can't click through it because it's
No,
yours.
it's not.
But see how when I have it pulled up here,
Yeah, when I do
it shows that you do slideshow and then do
All right,
current one.
let me do this. Thank you.
Okay.
I tried to make that go away from the slides. I couldn't make it.
You
go away.
can. It's a lot of work.
It keeps coming back.
Really? Okay.
Put on the right. There's something.
You want the clicker, so pull it up and then you just flip through it with this, or you can do that with your space bar, I guess, too.
I think space bar was fine. I think
Okay.
what gets weird Boy, I hope I don't have to read all these. Presenter view.
So just do
Let me get where I'm supposed to be, first of all.
start slideshow and then from current slide.
There we go.
And then it should
Then
show
it
any of
works.
that.
Then it should go. Okay. Thank you.
Okay.
I didn't realize you all were seeing that. I don't know why. Anyway.
Yeah.
I tried to make it go away as I was doing it, and obviously every slide doesn't need to have a title.
Right.
And especially you're doing
Right.
something, and then I couldn't make it go away.
Yeah.
So,
there's that.
with me sitting here.
Okay. Well,
This
I
is-
mean, either
But
way.
thank you.
All right.
I can only see 4 or 5 people, which is fine. Are you seeing
Yeah.
20 or something?
Yeah. So I minimize everything, and so that I have it's 18 or something, and then I just flip
Okay.
through them. Occasionally, I'm trying not to watch it too much because it just drives me
No,
crazy.
no. Yeah.
Because I'm trying to be less. You must be, and just be like, look, they're there.
Don't sweat it too much.
Yeah, I'm just trying not to sweat it too much. As long as they're there, I'm just gonna.
The one thing I absolutely can't do is catch the raised hands or the chat. So I'm glad you're
Okay.
telling me, because I
Yeah.
can't.
All right.
I can't get them. So thank
There
you.
might be a little bit of a delay, but.
No, that's okay. You should be. You should be. Yeah. Thank you. No worries, my friend. How's next Friday?
Dennis,
Oh. Give me 1 second here. Yeah, Shelby, is that you?
yeah, sorry.
Yeah, hi. That's okay.
I'm putting you through the TV right now so
Nice.
that you're bigger. Is that okay if I do that? And then my video thing will be of the whole room because I'm putting it in the front of the room. Is that okay?
Yeah, sure. That's
Okay.
cool. Yeah.
Because Debbie and I are together so that way we can both, before we were kind of echoing, so now we can see it on the big screen.
Right. Okay. Yeah, that's great.
Okay.
Good for you. Do you have a? Yeah, go ahead.
One more question on the assistants. So if there's not regulations written in there anymore, does that mean they can do more than they could do before?
Great question. And my take on it is no. And that's based on what's left in writing and also based on what they said. But most importantly, what's in writing. Well, yeah, there you have it. It doesn't let unlicensed people do any more. And I think that's kind of where they came down with the whole thing, is that they didn't need a special regulation for this. And as we get further in the material, eventually you'll come to a point where we'll see that they specifically say, brokers, you've got a duty to make sure that everybody is carrying out the law, licensed people, unlicensed people. They came up with a list of folks, but I don't think that they in any way have in writing or intended to allow unlicensed people to do anymore.
Okay. All right.
Yeah,
Thanks.
sure. Great question. Oh, I was going to be nosy. Do you have a smart TV? How is it that you could do that screen share like that?
I just connected it through an HDMI cable.
Okay, and threw it up there. Okay, cool. Yeah, good for you.
Hi, Shelby. It's Jessica.
Hey, how are you?
Just fine. How are you?
Good.
I sent you a message on Messenger, FB
Oh, you did?
Messenger, but I was like, hey, I'm here with your mom.
I didn't see it. I was following the rules, not looking at my phone.
Well, I did that before we started. So
Let's see here. I guess I
good
need
to see
to.
you.
1 minute before we go back and go. Let me, okay, welcome back everyone. I think I see most people. It's an awfully nice looking kitchen there, but we need a body on it. There we go. And by the way, just so you all know, Virginia Lawson, Jenny Lawson, the reason you're not seeing her is she is not taking this for credit. It's not like she's getting some special treatment. She's not taking this for credit. So she's just monitoring. That's why we don't have to have her video on. And she's monitoring, not for credit, which is why you get to do that. Okay. Speaking of which, this seminar is being recorded, and since we've got almost half brokers on here, I will say I think GLAR intends to make this available. If anybody wants it, they could have it to, I'll just say, play in your office, but of course that would be not for credit. But if people just wanted the information, they could certainly watch it that way and get the information. Okay, well, we're back. Welcome back from the break. We just got through talking about the regulations, taking cognizance of Dropbox and other similar delivery systems. And designated agency, you know, that's nothing new for almost 20 years at this point. So it's in here again. Definitions, you see it's all in black. There's nothing been changed about any of that. They didn't make any changes here in dual agency. And they did come up with definitions for duplex, triplex, fourplex, because those things matter as we get into what has to be disclosed and not. They explicitly told us, and this was helpful, that an education cycle is 1 year. And even though your license cycle is 2 years, your education cycle is 1 year. So that'll matter based on how we see education cycles defined. An interesting change here, remember light blue means it's taken out, is what is a family relationship? Again, this has to do with agency disclosure. Family relationship is any known familial relationship between a licensee and party. It used to say, regardless of the distance of the relationship, they took that out. They took out those words, regardless of the distance of the relationship. But I will tell you that still, any known family relationship to me, still means, regardless of its distance, because it's got to be known to you. So if you don't know about it, you're not going to be held liable for it. But if you know it, you ought to be disclosing it as a matter of safety. Here's our definition about a fourplex. The fraud definition, you see mostly no changes here. It tells us initial sales license. There are some changes here in terms of how do people licensed in another state get licensed in Kentucky now. And notice that they took out license recognition, and we now are going back to license reciprocity. What that probably doesn't mean anything to any of you. I'm assuming you're licensed in Kentucky or you wouldn't be taking this class, I assume. But it does matter to people who are licensed in Ohio and Indiana and Tennessee that want to get a Kentucky license. What it basically means is that the KREC negotiates agreements with those other state real estate commissions, and we will be as nice or not nice to their people as they are to ours. That's what reciprocity means here. And we now have in place a reciprocity agreement with Ohio. We don't have any in place with anybody else. They're still negotiating those. But that's what that's about. Personal relationship, again, as far part of agency disclosure, means what it always meant. They gave us a definition of what is a promotional activity. And again, they've put in some business in here about timeshares, even though most of the timeshare regulations are gone. Now, one thing that has changed in the regulations that I consider significant legally is there's this new group of people or new classification of people called prospective clients. And as we're going to see, you're going to have different levels of duty. Obviously, your highest duty will be to a client. Your lowest level of duty will be to consumers, people you don't have any relationship with. And the in-between level of duty is going to be with these prospective clients. And those are people that you don't have a written or oral agreement with to provide services, but you've received confidential information from them, or you've offered real estate brokerage services to them. So that makes sense, right? It's a prospective client, just like it sounds like. The one thing that you need to be sensitive to is that somebody can make themselves a prospective client if they share confidential information with you. So just know that when that happens, they're going to get some elevated duty from you that we're going to talk about here in just a little bit. As we've already said, your renewal cycle for licensing is every 2 years, not every year. Single agency, again, this is one of these things, it's a new, by regulation, a new definition, but I think it's not anything that we didn't always believe, is that's when you're representing one side of the transaction only. Single family residential dwelling, which of course is going to matter for a lot of agency disclosure as well as seller's property disclosure form. They took out some things and put others, a standalone unit, a manufactured home, even part of a larger. All right, here's one of the most significant changes, I believe, in the new regulations, and that is having to do with teams. And I'm going to, for myself, I'm going to open up a gallery view so I can see more of you again. And I'm just going to ask for a show of physical hands. How many of you are in a team or a group or something like that? You hold yourselves out as some smaller part within your firm. Okay, that's what I thought. That's it's becoming more and more common. And for the first time, the regulations acknowledge such a thing as a team. And As we're going to see, there's going to be requirements here about teams and how you advertise, and especially half of you said you were brokers, you're going to have some special duties about these teams. So a team has to all be with the same brokerage. There has to be a team leader, and you hold yourselves out together as a group within that brokerage. That's what a team is. The team leader is the individual who's designated by the broker to be the head of the team. And I will say, I'll probably repeat this later, but just so you know, some of the teams that I'm just familiar with from driving around town, I'll see signs that say the A, B, C team. Makes me think you're probably equal partners, although your business relationship is nobody's business, but that's what I would have thought. And the KREC doesn't care really about your business arrangements, but they do care that you have a team leader. So even if you're equal business partners, you're going to have one person that is considered in charge and responsible for that team. They gave us a definition of townhouse, which means pretty much what you would have thought it meant. Also, a transactional brokerage was finally given a definition. Now, we've had transactional brokerage for years because your agency disclosure form, if you remember, down in subpart 3, where you could say you only had one real estate agent, you could have represented only the seller, only the buyer, or remember the last box said neither. And we've always thought that that was transactional brokerage, but we didn't really have a definition of it. Well, now we do. So we know that it's where you're going to treat all those people only as consumers, and you're not going to relay confidential information between the two of them. So you're not going to have a client. You're just going to treat them all as consumers. So you're going to be fair to both sides, but you're not going to have a client in a transactional brokerage relationship. I suspect that transactional brokerage is probably pretty rare. The explanation that was given by the KREC, at least when they were trying to put words into what this meant, was two people have already come to a handshake deal with each other, and they know that there's something that's more formal that has to be done, and they don't know how to do it. So they come to you and they say, our mutual friend, Keith Nutter, will you help us write this up? And we've already come up with the deal. Help us write this, put this together. And you say, of course, I'll do that. That's how they just defined that was their example of transactional brokerage. You didn't go looking either way. They just kind of came to you. You didn't have a client.
Transactional is different than limited service then?
Well, that's a great question. Yes. And so the answer is yes, because the regulations do not define limited service. So the limited service brokerage is much more just a function of contract. And as far as the KREC would be concerned, that limited service, I'm going to say lister, they are truly your client as far as the KREC is concerned. Great question. Great point. They gave us a definition of what's a triplex. And without delay, which is, as you know, is the time frame within which you're going to have to deliver all offers, is as soon as reasonably possible. They've made a couple of changes here that I think are good. One thing is they've said that that's based on the availability of the licensee and the client, and it acknowledges that you just can't be available 24/7. You are going to be out of town, you're going to be out of phone range, things are going to happen, and that's still without delay has to take acknowledgement of that. Also, for the first time, it explicitly added subject to any written agreement between them as to how and when written offers will be submitted. And I know that it seems, especially in today's world where you're getting multiple offers, I think that's what's driving it, is that you're getting clients who say, I don't want to see any of these offers until Sunday night at 5 o'clock. That's when I want to see them. Don't be giving them to me all day, all weekend long, and drive me nutty. Sunday at 5, we're going to look at them all. If your client gives you that written direction, and that is a legal direction, then that's going to be the without delay, is you're going to deliver them when your client told you to. I think we lawyers always thought that was the case, that would have been a legal direction you could follow, but this regulation now makes that explicitly clear that those kind of directions from your client are allowed. Now, without unreasonable delay, which is going to have to do with either depositing money or getting a seller's property disclosure form, we're going to know that that's 3 business days for the money. One of the things that they did change, which I think was a desperately needed change, is they made it clear that that's within 3 business days of your receipt of the money. Many of you were often out of compliance due to no fault of your own, because the regulation said you had to deposit money within 3 business days of the formation of the contract. But the truth is you didn't even get the check that fast, right? So how could you possibly have deposited it? So they've changed that. So now it's 3 business days of when you got it. So that was needed. And so with listed property, then you also then have 72 hours from the time you've got a prospective, a written contract or written offer to purchase to get a seller's disclosure form to the other side. You all here in Jefferson County probably never rely on that, because you almost always have this loaded up in the system, on the MLS system. So you've got it before you ever started to make an offer. You've had the seller's disclosure form. So you probably didn't even remember that was there. Okay, those are the definitions. And as you can tell, there's a lot of meat even in those definitions, and they anticipate part of where we're going to go here with these other regulations. Beginning with the advertising regulations is the next regulation we cover of the 7. It's the first substantive regulation, 105, which we used to have. So they've taken out some of that. And so this section 1, a licensee shall not advertise real estate for sale or lease without the written consent of the owner. Okay, hardly anything too surprising there. You can also shall not place signage or other advertisement on any private or listed property without the written consent of the owner. Now, I put a purple splat mark on this, and I don't mean to start a furor, but what we're going to see is that you actually can be retained by a client to advertise their property even though you don't have it listed. See, it says private or listed property. I just thought that was very interesting. I don't know what you're going to do with that, but legally you would be allowed to do that. And we'll see another regulation here in a little bit that makes that even more clear. You shall not promote or advertise property listed by another broker unless you have their written consent. You all have something you call an IDX agreement that you do that with. I'm going to open up my gallery view. Let me ask for another show of physical hands, please. How many of you have signed off on an IDX agreement? I'm just nosy. I'm going to hang on, keep them up, because I have to use 2 pages to see you all. I'm curious. Okay, that's what I thought. It's at least half, and it may be even more than that. So that's what this one's about. There's no change here. This has been around for a while. Also, once a property's closed, anybody can use that information as long as you use it truthfully. If you're an agent for a buyer, once something's closed, you can accurately talk about that and advertise it, as long as you make clear that your participation was as a buyer's agent. Some of you do that, I know. I get some mailings from you occasionally telling me that you've been the buyer's agent for something. Now, here's the regulation that went away. The blue part doesn't say it anymore. So it used to say that in order to promote or advertise real estate to the public, the broker shall have a written listing agreement signed by the owner. That's gone. So the listing requirement is gone. And they, again, back there about 5 slides ago, specifically said that you could advertise property that was either private or listed property as long as you had the consent of the owner. So to me, it's very clear that the KREC does not require you to have a listing, doesn't require you to have a listing to advertise property. You do have to have the client's written consent. And of course, if you do have the property listed and you're using the GLAR form, that does have that consent in there. I don't know how many of you would advertise property that you didn't have listed. I'm going to open up the gallery, but before I ask for a show of hands, I'm just going to say, the more I thought about this, it was like my 10-pound dog chasing a car. It's like, now dog, if you catch that car, now what are you going to do? So if you've got it advertised, but you don't have it listed, now what? So I'm curious, how many of you would advertise property without a listing? I mean, you've got the written consent of them to do it. I'm not seeing any hands go up. I'm seeing John saying he's throwing over into his waste can, throwing up at the thought, right, John? That's his take on it. I tend to agree with you. I don't know what the thinking was, but I can see why they would allow it. And I will say the one thing that does make sense for me that is specifically this allows is your client says, I'm gonna list this property with you, but it's a mess and I need a month to clean up the mess. Let's go ahead and sign the listing, but let's advertise later or advertise at a different time. I mean, that's the only thing I can even contemplate. And we'll see another regulation change that anticipates that a listing could be effective at a different time than an ad. I don't know if that's where they were headed with that or not. It's just interesting to me. Okay, I know half of you are brokers. I want you all that are brokers to get out a much beloved Post-it note or something that you take notes on. And there's going to be 3 things that you're going to have to get a written policy in place about. They're all things that you probably are already doing, but you're probably currently doing them verbally, and you're going to now have to do them in writing. And this is the first one, and that is, brokers, you have to have written standards for review and approval of advertising. I'm sure you've already got something that you verbally have told everybody, and that is what you're doing, but now you need to get that in writing. And this is one of the first places we see the KREC tightening up both the rights and the responsibilities of brokers. So good news for you brokers is they've made it more explicit that you own the listings and that you're in charge. And the bad news is they're going to make you document some of that, and some of your responsibilities that you've carried out verbally, you're now going to have to carry out in writing. Okay. Here you go. They're making it clear that you shall be held liable for acts that you knew or should have known are in violation of the law. They're making it much more explicit that you're responsible for those ads. Mostly this is not new about advertising. It has to have the name of the brokerage or the principal broker. And if it's of the principal broker, it's with a clear designation of that principal broker status. That rule's been around, I'm going to say, forever. Notice that they did add registered with the commission. And again, this has been their policy all along, but now they're making it very explicit that the company name or the broker name has to be the name that's registered with the commission. Is what has to be in the ad. And we'll talk more about names and registrations here in a bit. All right. They tell us that an ad may include a licensee's first and last name, or an alternate or assumed name as set forth in section 4. I'm going to jump ahead and cheat and tell you that what that is a team name. All right, that's what this alternate or assumed name means, a team name. So it can either have the licensee's name or the team name, as long as the broker has informed the commission of that information. So again, brokers, you've got some duties here. So you have to have the broker or company name. You may have the licensee or team name. Now, when it comes to your individual names, you are now, for the first time, specifically allowed to use a nickname in place of or along with your first name. And it's your duty to register your nickname with the KREC. I'm going to, there's a form for that. It's Form 201. There's a fee for that. It's $10, I'm pretty sure. And let me tell you the bad news is a whole bunch more of you have nicknames than you might have originally thought about. Because, let's see, I'm going to pick on my friend John Fishback here. I'm just going to make a wild guess and suspect that John is not what's on your birth certificate.
Well, it is.
Oh, it is. Oh, man, I missed it. Fran. Fran is probably not a name on a birth certificate. Also, by the way, Fran, do me a favor and turn a light on or something so we can see you there. We got to have visual on everybody. It's probably Francis or Francine or something like that. Whoever's out there named Bill, I bet your birth certificate says William. My friend Tim, I bet your birth certificate says Timothy. May be wrong, but yeah, he says I'm right. Every one of those things, even though you and I clearly know that Tim is the diminutive for Timothy, the KREC says that's a nickname, and they want those things registered if that's the name you're going to use on ads, okay? So, and there are still some questions left unanswered by that, a couple of them I've submitted in writing to the KREC because I'm very curious what their answer is going to be. My name happens to be Dennis James Stilger. So I would, if I was a licensee, using Dennis Stilger would not be a problem. But some people with my name would decide that they didn't want to be Dennis Stilger. They would want to be James Stilger. And they would use James, my middle name. And I'm not clear whether that is going to be okay with them or not. So I've asked them that question. I don't have the answer yet because I just asked them, and so they haven't had a chance to respond.
Dennis, is the Form 201 the same procedure for nicknames and team names, or are there two forms?
It is the same form, and we're going to look at forms here in a little while. I'm going to give myself, thanks for that question. I'm going to pull up my Post-it note, and when we pull up forms, we're going to look at Form 201 explicitly. Form 201 is pretty much the workhorse of the KREC on names, affiliations, and all kind of things. We'll take a look at it, and it's got a lot of different things that gets done on Form 201. So just so you know, you need to register those nicknames, and nicknames include diminutives of first names, even though they're very common. Everybody should know that Bill means William, but they want them registered. They want what's on an ad should be what's on a license, and if it's not what's on the license, they want it registered. Okay. Now, remember that you had to have the company name or broker name. You're allowed to have your licensee name or your team name. The regulation is now clear that the broker or company name has to be, first of all, in written text, clear and visible to a typical observer of the advertising, okay? Not false, misleading, or deceptive, okay? We're still good. And that the team name or your name cannot appear larger than the broker name or company name, all right? So the broker or company name has to be the bigger of the license names that appear on an ad. And the KREC put a delayed effective date on all of these advertising regulations until June 19th, which of course is not far off, but specifically to give everybody an opportunity to get their advertising in compliance. And I'll say specifically think about your signs, because you're going to have those paid for and printed and that kind of thing. And with that, we're going to do our first breakout session. If I can. Okay, we're all back. And I'm gonna, okay. I'm gonna ask for, we had 5 breakout rooms, and can I get my, let me start, I popped in on a handful of you, but I did not get a chance to pop in on everybody. So I'm not sure who's in breakout room 2 and 4. But I'd like to hear from them first, and I've kind of planted some questions in groups 1, 3, and 5. Group 2, do you have a spokesperson? Group 2, do you know who you are? Whoop. Yeah, can you unmute everybody? Phaedra.
His lips are moving on mine, not up there.
All right, I think we're trying to unmute you all.
I don't know what number we were.
Okay, my bad. I should have told you your group number was in the top of your screen. Let me go to, let's go to group 3. I think that was Keith. Were you the spokesperson for group 3?
Oh my gosh, nobody know how to.
Uh-oh, we got a tin can effect. I think somebody's got 2 computers in the same room. I'm going to blame Debbie Freeman, maybe. Sorry to say it, but it's probably.
You're still unmuted.
I have it on mute.
I'm going to mute one of you and see if that helps. Oh, that did help. There we go. Sorry to pick on you like that, but I think it was you. All right, Keith, were you the spokesperson for A group?
Well, I wasn't, but I'll go ahead and do it.
Okay. Oh, who was your spokesperson? I didn't mean to.
Willie said.
Willie. Okay, Willie, on behalf of group 3, I guess it was, wasn't it?
I don't know.
Okay, A group anyway.
Okay.
So let me let me ask. Did everybody in your group, Willie, was their sign going to be okay?
I think Keith said he probably gonna have to change his because some of the verbiage on it is larger than the company's name, or some of them don't just fully disclose everything.
Yeah. And how about in your group, Willie? Did you have other questions that I didn't answer up until now?
The way I understood it is if we use a directional sign and it's just got the arrow on it,
Yeah.
nothing else, that's okay. But if we use a directional sign, it's got a phone number or the agent name, it's got to also include the company or the brokerage names. That's correct?
Yep, give Willie a round of applause, either physical or virtual. That's exactly it. And so that may throw a twist at some of you because of, I see yard signs all over the place. I see directional signs all over the place. Sometimes I see them with some identifying information, sometimes not, but that's exactly right.
Hey, Dennis.
Yeah, yeah,
Uh,
Tim.
we use riders for
Yeah.
our name and phone number.
Yeah.
So does the rider connected to the sign have to apply as if it was on the sign itself?
I believe it does. And so there's one of the questions that's not specifically answered, but I am 99% confident that yes, it does. That as far as the KREC is concerned, the sign and then the rider collectively is looked at as one thing, and that agent's name on that rider shouldn't be bigger than the brokerage name on the sign. That's a great question.
But
Yeah, Willie?
I got a question. But on the directional, let's say, for instance, on the router itself, it don't have to include the brokerage name on the router. I think that's what Tim was asking.
Oh, I'm sorry. Okay, yeah, no, it would not.
Okay.
Because you'd have the broker's name on the main sign, your name on the rider, that's good enough. I mean, you're good. You get to take credit for the sign as a whole.
Okay, I understand.
Thanks for that clarification. Well, you're absolutely right. Yeah. I planted a question. John, where are you? John Fishback?
Right here.
There you go. Come on, throw it at us.
No, I think all of us were in compliance. Most folks used a standard company main panel in an agent rider.
Okay.
So it's only in rare circumstances where the font of that rider would be bigger than the main panel. And then large franchises, I think the fonts are close depending on the franchise.
Yeah.
So obviously in the next round of signs or the next round of stickers that go on the main panels, we could have those made slightly more, slightly larger.
Yeah. Yeah. Okay. Good. And I used signs as an example, but remember this regulation is all advertising, not just signs. So when we'll talk a little bit more here in a minute about internet advertising, on, and there are going to be some exclusions as well, but this seemed like a good spot to have a break. Any other groups have questions or quirks or problems other than just do you comply or not? No? Okay, give me just a second to manipulate my screen and get this going back up and do a screen share on. One second, hopefully. Give me a hard time. Sorry.
Dennis,
Yeah.
do you think that rule applies on business cards also?
Absolutely. And that's a great question, and absolutely it does. Thanks for asking that. But yes, we're going to come up on a slide here in a little bit on some things that are not advertising, but business cards is not one of those. So great question. Yes, it applies. Here we go. Here's where we were, design your yard sign or evaluate your yard sign. So yeah, there are some more clarification in the regulations. Next one's telling us some things that don't apply, that the requirements do not apply. So hats, pens, notepads, apparel, name tags, and the sponsorship of charitable and community events. So you can have the Tim Powers Pirates and as a little league team, and that'll be okay. And then any of these things, you don't have to comply because they've explicitly said you don't. They know that they didn't think of everything in the world, and so they've told us that they may waive those requirements on other specific promotional materials. So if you've got some other kind of promotional material, you know, I don't think they said anything about refrigerator magnets and calendars and all kinds of things. You're going to need to run them by the KREC in writing and see what they say about, is this going to be okay without that or not? Now, the internet advertising rules have changed in some important ways, beginning with, you remember we used to talk about what requirements for home pages. Well, those requirements are gone, and instead what we have is telling us that for purposes of internet advertising or any kind of digital advertising, every individual viewable page or post shall constitute a separate ad. So you may need to talk to your webmaster about how your web page gets set up. And again, they're telling us every ad has to contain that section 2.2 content. That's the broker name or company name. And it has to be visible on the page or post without scrolling or otherwise navigating to find it. The thing that's I don't know enough to understand is if I pull your web page up on my laptop, it seems to me like it looks differently than when I pull it up on my phone here. And so I don't know what they're going to do about that. I think to the extent that you can, you want to make it that the required content, the broker name or company name, is front and center on your web pages. And that way there won't be any navigating or scrolling to get to them. Note that they've, at least for the KREC purposes, have taken out the requirement that you have an address and a phone number. That used to be something that was in here, and now it's gone. So you don't have to have that on every page, but you do have to have the broker or company name. And again, they gave us an out, and they've said if the page or post cannot reasonably comply with the requirements, then the advertisement shall include a clickable direct link that's clear and visible and identifiable as a link to that information. So they have not made the link the first choice. They've only made that the method of last resort to get to that information. So I know that they don't like the clickable link, and so you should only do it if you absolutely have to. There's also audio-visual presentations, things like YouTubes, and well, YouTube is the one that comes to my mind is the platform that you put them out on, but any kind of audio-visual presentation. Oh my gosh, it is. All right, let me do this slide. It's almost break time. I can't believe it. Audio-visual presentations have to have either an audible announcement or a written display of that information at the beginning. And yeah, let me do one more thing and then we'll take the break. So the quirk or the challenge that you may have is that you have audiovisuals, virtual tour kinds of things that you've posted. The MLS rules prohibit you from having those branded. The KREC rule, in effect, requires that it be branded. You're going to have two versions. And it's not that it is not that MLS overrides KREC. It does not. But when somebody gets to it through the MLS, they will have caught the branding on the way in. Does that make sense? And so you've branded it by virtue of it being on the MLS. But if you then turn around and want to put it out on your own website or make it available on YouTube in a general way, then you have to have the audible announcement or written display. So you may have to have two versions of YouTube's virtual tour kind of things, one with the branding and one without. And all, and let me pick it up again. Okay, we were at the slide talking about what I call the YouTube slide, audio visual presentation. So they're telling us, so moving on from there, internet ads that were true and correct at the time they were made shall not be in violation. I don't think they're telling you can leave your I know they're not telling you can leave your web pages up the way they are forever. They're just telling you that something that was okay at the time, true and accurate, is not going to be considered a violation. They're still going to require you to get your broker name bigger or company name bigger than your team or personal name. Here's a rule. Just there's some clarification to this, not as much as you might want, but they're specifically telling us that a logo that doesn't have text does not substitute for the content. And I hate to use trade names, but I have to because it's the one that comes to my mind. And I bet you would all know what company we were thinking of if we talked about a red, white, and blue hot air balloon. I bet you would know what that was, but that's a logo, and they're telling us that that logo alone is not sufficient to replace the broker name or brokerage name, either one, that only the written text part of that balloon is going to do that. They still tell us if your principal business location is outside of Kentucky, then you have to state you're Kentucky licensed. And we already knew by the definitions that a pure directional sign wasn't advertising. Now they're also telling us that this does not account to logos, brands, directional and open house signs, as long as they do not contain the name of a sales associate. So any of those things that don't have the name of a sales associate, you don't have to go back and retrofit. All right, alternate or assumed names. I cheated and gave you advance notice that this meant team names. So they're telling us that as a team, a group, or whatever your business arrangement is, you can use an alternate or assumed name. And for that matter, a brokerage company can as well. You know, you've got all kinds of names that for decades you've been, you know, you were actually XYZ Corporation doing business as ABC Realty. But specifically what this is going to come down to is team names or group names can be used. But again, the broker's got to approve that. And prior to allowing the use of that name, the principal broker, so this is the second thing I'm telling you brokers have to do, is make sure that that team is registered on the OPP site. Again, there's that form 201 that's going to do that. And that an alternate or assumed name, now here's what the regulation says. I think this is interesting. An alternate or assumed name shall not contain terms that lead the public to believe that it's a brokerage. Okay, unless it really is a brokerage. Now, that's all the reg says. And of course, that it can't be used by more than one group of licensees in the same brokerage. That would be confusing. And you can have team names that have a human being name as long as that human being has the ability to engage in real estate brokerage through administrative discipline or by operation of law. So I think what they're saying, obviously discipline. Operation of law would, I would think, also include death. When I'm death, it's real estate. So you can have a team name up until then. They tell us specifically that the alternate or assumed name, so the team name, has to end with, shall end with the word team or group. I have been told anecdotally that a long-standing group that was called, I'm just going to make this the name up, but Team Smith, that Team Smith said, well, hey, how about us? We've been Team Smith for 20 years, and I've been told that the KREC approved that. I can also tell you that when that same issue came up before the KREC meeting in May, just a few days ago, they said, no, you can't do that. So hopefully whoever that group was that said they were was told they were grandfathered, I hope they have that in writing, because the KREC as a whole has not acknowledged that they would honor any kind of grandfathering. They tell us that false, misleading, and deceptive advertising is prohibited, of course, and obviously that's known or reasonably should have been known to be false or contrary at the time of placing the ad, misleading or misinforming the general public, and specifically a false ad is something that would lead a reasonable observer to believe that real estate brokerage services were being offered by a licensee or group of licensees independent of their real estate brokerage company. Here's the interesting thing. The KREC discussed this in quite a bit of length on May 21st, and their policy, it's not in the regulation, but their policy is that any team or group name that includes the word realty or real estate, they're going to treat that as a violation of this regulation. That in their view, I'm going to go backwards a second, that in their view, that would lead a reasonable observer to believe that real estate brokerage services were being offered by the team independent of the broker. For what it's worth, I don't agree with them, but they're right. They're the ones that make the rules, so they're right. I don't know why realty or real estate necessarily would imply independence from a brokerage company, but to them it does, and maybe they're right. I just, it didn't seem like it did to me. All right. Guaranteed sales plans. Very few of you have ever seen or heard of a guaranteed sales plan, but there is such a thing. In short, it is, if you don't sell your property when I have it listed, I guarantee you that I'll buy it from you. So you can do that sort of thing. There's a lot of rules around it. I did not put all the rules in here, but the one that I did put in here is that they're telling us that there's those disclaimers there have to be at least 25% as large as anything else in such an ad. And if you're doing a guaranteed sales plan, you're going to need to pull this regulation. I did not, that's what those 4 dots were about. Is there's a whole lot more about it that was beyond the scope of this seminar. Let's see. Oh, sorry, there we go. You're required to advise your clients of these regulations. Again, if you're a GLAR member, you are doing that because the GLAR form listing, multiple listing, has those words in there. So if you're using the GLAR listing agreement, you're doing this. Here's the delay that was given way back in December. So before anybody heard of COVID, that they would delay the enforcement of this until 6 months after the effective date of the rest of the regulation. So the rest of the regulation was effective December 19. We've got, you got some time to get yourself in compliance, but not much. Now, one question that commonly gets asked before I pass this up is, well, you know, what's going to happen? And the answer, I guess, is going to be, well, the KREC has a investigator who's mostly busy dealing with actually filed cases. So I don't believe that that investigator is going to go around the state looking for your sign. But what will happen, of course, is, you know, competitors might well say, I'm not happy about this, and take a picture of a sign and send it off to them. As far as I know, they haven't been getting a deluge of those yet, but I suspect that that's, you know, it will happen. So you want to get yourself in compliance as soon as you can. I know this, again, was a quick summary, so if you're certainly, I encourage you to go pull the regulation and take a look at your business card, your website, your signs, whatever you have, and get yourself in compliance as soon as you can.